This content is brought to you by Uphold, which is a great platform that makes crypto investing easy. You can buy, sell, trade, and earn cryptocurrencies on Uphold. They have 10 plus million users, over 200 plus cryptocurrencies, and they're available in 150 countries. I personally use this platform since 2017. They're one of my go-to exchanges. They also offer equities and precious metals that you can invest in. If you'd like to learn more about Uphold, please visit the link in the description. Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is attorney John Deaton. Attorney John Deaton is no stranger to the show. Today, we're going to talk about the LBRY case, the Ripple case, and crypto regulations as it relates to the SEC. John, great to have you back on.
Thank you, Tony. Appreciate you having me, brother. Hope you're well.
For sure. John,
how's your mom doing?
She's doing good. She's of course asking me, what's the price of Bitcoin? What's the price of Ethereum? What's the price of XRP? And but she's passive, right? She's just like, oh yeah, I just want to make the money and as an investment and things like that. So,
you're going to get a lot more of those questions if we get into another bull run, because it seems like when Bitcoin's going way up is when I get all my requests. Like, should I buy? Should I not buy? Got a lot of people asking me at 50,000 whether they should have bought. They weren't listening to me when it was at 5,000.
Right. Yeah, it's funny, right? But I think the data shows when Bitcoin moves, it's like the gravitational pull, the alts start following. And that's been kind of, in general, the movement of the market.
Yeah, I mean, the theory is that at some point utility will win out, right? As versus just speculation. And I think that, we'll see. But you're right. I think that if Bitcoin enters another bull run, obviously the alts are going to probably run with it. You know what I mean? But at some point, and whether that's a year from now or 5 years from now, you would think that utility will win the day.
For sure. I think we'll eventually get there as things start to mature and there's multiple iterations and so forth. Let's talk about the latest updates with the LBRY case. Obviously, very timely, with the rulings and the statements by the judge. Give us the latest and the greatest there.
Well, a lot of people were questioning why are you getting involved in LBRY, because, LBRY lost. And there's always two phases to a case. The first phase, and this applies to Ripple as well, the first phase is whether or not the judge is going to decide whether a company marketed and packaged, offered and sold a security, an investment contract. So the judge found that LBRY violated Section 5 because he decided that the sales that LBRY made to certain individuals or people constitute an investment contract. He talked about how LBRY's market cap, the LBC market cap, went to 1 billion when there were only 4 videos, right? And so when they first started out, it's, you're first starting out. And so 4 LBRY videos and LBRY did 3 of them. And so those initial sales he found to be securities, but he wrote the opinion very vaguely. And it was interpreted by very smart attorneys like Lewis Cohen, who wrote that huge article that researched, 76 years of case law in securities. And it came back to, is he saying the token, that the LBRY credit itself is a security? And so after you get a decision, you go to the remedies section of the case. It's sort of like a criminal case. You have guilty, not guilty, and then you have sentencing, right? Same kind of concept with civil cases. You're liable, and now what should be the penalty? And the SEC was asking for a permanent injunction. And the permanent injunction they were asking wasn't limited to LBRY and its executives. It said all persons in common. That was the language, that the court is going to enjoin all persons in common with LBRY.
Mm.
So does that mean LBRY token holders are in common? It's so vague. And token holders like Naomi Brockwell, she has a channel just much like your channel, and she's trying to generate views, and she uses the LBRY credits. She has to access the platform, and she stakes her LBRY credits in order to get views and try to build out her content and her channel. And she never purchased a LBRY credit in her life, and she's never sold one. She truly utilizes it for the platform. And so clearly what she owns is not going to satisfy the Howey test. For one, it's not an investment. She never bought one, right?
Yeah.
Two, she's using her efforts to build her channel and to benefit from it. So she doesn't meet that. Arguably, I said in court when I showed up was, the most that they could hope for, the SEC, is, are they going to claim that Naomi Brockwell is in a common enterprise? They can't. But even if they did, they lose on the other two prongs. So I'm saying to Judge, there are these users out there. There are users and token holders. And your decision, it doesn't apply. It shouldn't apply. And it can't apply to the secondary sales. And so that was very important. Had the SEC won that injunction and the judge just rubber stamped it, then we'd be walking around today saying the judge basically said LBRY credit is a security in and of itself. And so that's why we had to fight, because everybody who's been following me from day one, I've said to the SEC, if you want to go after Ripple, whether you should or shouldn't, I don't care, right? I don't want to hear, I don't care. Then go after them.
Right.
Leave Tony's mom alone. Leave John alone, right?
Yeah.
Leave my daughter Jordan, who never heard of Ripple. She just bought the top 3 tokens. That's all. Exactly. With her 15 grand, all she did was buy Bitcoin, ETH, and XRP. She didn't know. She never heard of Vitalik Buterin. And she bought ETH, right? Exactly. So leave us alone. Go after Ripple. If Ripple violated the law, fine. If LBRY violated the law, fine. But it is absurd for anyone to say that this software code is a security, right? That's it. And that's why I've given the examples many times of, Bitcoin was used as an investment contract in the past. But everyone accepts that Bitcoin's not a security. Beavers were used. Right. Condominiums were used. Chinchillas have been used. You can take any asset, Tony, any asset. You could take an iPhone, doesn't matter, or a commodity, gold, and package it in a way and say, hey, I'll give you, if you give me money, I'll give you this gold thing, this token that's like, say it's tokenized gold or something. And you're going to rely on me and I'll make you money. That would be an investment contract scheme, right? Right. But that doesn't mean that the token that's tokenized gold or the XRP or the LBRY credit is itself a security. And in 76 years of case law from Howey, not one case has ever found that a subsequent sale of the asset that was determined to be used as a security is a security. And there's not one case in 80 years that has ever said the underlying asset is a security, right? And so I was in court fighting for that, saying, fine, LBRY laws, I don't care. Like, all I care about are those users and those token holders. And so what the judge did was basically say and give clarity, and we're waiting for him to put it in writing, of course, but it's on the transcript, and we'll all get that eventually. You'll be able to read that. I'll put it on Crypto Law. And he basically said, my decision was that LBRY violated the law. And that LBRY used LBC as an investment contract. My decision does not apply to secondary market sales. And let me give everybody like an example. Your audience, Tony, because this is so important to the market, to all of crypto, the
Absolutely.
secondary market sells. Let's take the Howey case. Everybody knows Howey involved land contracts, orange groves,
Yep.
and people would buy, they could buy a half acre, a quarter acre, an acre, whatever they could afford. And then they would sign a contract with the Howey company who would then maintain it. So there'd be a land real estate contract that was signed and a service contract that was signed. They would go home and then Howey would do all the work, sell the oranges, and then send them their pro rata share profits, right?
Mm-hmm.
And so that's all it came down to. That was an investment contract. Now, let's say that the person who signed the Howey contracts, who was relying on the Howey company, let's say that person then 4 years later sells that 1 acre of orange grove. Say they have an acre. They sell it to you, Tony. They never mention Howey. You don't even know about Howey company. You just like, I want an acre of orange groves. Like, I think that's a good investment for me.
Sure.
I want to buy that. It would be absurd for anyone to think that that second sell to Tony, who's never heard of the Howey company, didn't even know they existed, who just bought some land of orange groves. And that's the same. So what the SEC is trying to do with digital assets is say that the token itself is a security. That's what Gary Gensler is trying to do.
Right.
And so for everybody to think about it, just think about that Howey second sell. And what the judge finally did on the record is he used a great example. And he said, because LBRY sold some LBRY credits early on to an entity called Flipside Crypto. And Flipside Crypto was an investment club in cryptocurrencies. And they took the LBRY credits, say they bought a couple $100 million, I don't know what the actual number was, and they put it in a cold storage wallet. Clearly, it's an investment. It's an investment club, right?
Right.
So, and it was a direct sell from LBRY. The judge found that was the sell of a security, right? That sell of LBRY credits to Flipside was security. But he said, but my decision has no effect if Flipside sells it on Coinbase to someone else. My decision does not apply to that scenario. So what's that mean? It means he's saying that the token's not the security. Because if the token was the security, if LBRY credits were a security in the judge's mind, then all the sales would be a violation because it's a security and it's not registered. So that's the rationale. And it's very frustrating for someone like me because it's so common sense, right?
So logical, yeah.
Like oranges aren't securities. Bitcoin's not a security. Beavers aren't a security. XRP is not a security. LBRY is not a security, etc. And so, but that's the fight, and that's what we're fighting. And since there's no legislation that's coming down, these court decisions are big, man. They're big. Yeah. And so that's why, I was very thankful, and I want to give credit to Naomi Brockwell, because without Naomi, I could have never got in there, right? I had no standing. I'm not a liar. I don't own LBRY credits. I never have, right? So I don't have like a interest in LBRY itself. And so if she didn't have the courage to say, you know what, go ahead, John, fight. Let's fight back. This is absurd. What the government's doing is wrong. And without that, we wouldn't have been in there. So I want to make sure that people don't just, I really appreciate and love everyone's support, but she needs a lot of it. You know what I mean? Because, without her, I would have just been sitting here complaining and not doing anything.
And very similar to Naomi, I have a LBRY TV. It's now Odyssey, of course, but I had set it up since 2018. I was earning LBRY tokens. I never bought any LBC. I never sold it. I was just accumulating it through my activity, my content, the views. And if I go on the platform, if I went and even logged in and viewed other people's channels, I earned. And very similarly, it was just sitting there in the wallet. And I can't imagine, I was just earning it, but similar to what you were saying with Naomi, how am I involved in some sort of scheme with LBRY?
Exactly. And Naomi actually, and she had an affidavit that I submitted to the court where she said, look, for the first couple years, I didn't even know that it had a value. Like, I didn't know that you could go trade it. And like, you know what I mean? She was unaware it had a monetary value. To her, it had a utility value.
Right.
That was the entire value. And as she said, it is more valuable for you or her to hold the LBRY credits, stake them, use them, than it is to sell them for 2 cents or 4 cents or 1 cent or whatever the hell number they're valued at. It's much more valuable for the user to keep them. And so there's nobody's definition. I stood up in court and I said, the one thing that I have to believe that the SEC would agree with me and that the judge would agree with me is, I said, nobody in this court can say that what Naomi Brockwell holds is a security, right? And that Howie would be satisfied. It won't. It can't be. So if the SEC agrees with that, and what everybody needs to understand is the SEC conceded to the judge. They said, we agree that there are many, many LBC token holders who never viewed LBC as an investment. They are users of a decentralized platform. They agreed with the judge. They stated it on the record, Tony, but they refused to give a no action letter on secondary market to someone like Naomi Brockwell. If you do transfer it, or flip side crypto, if you transfer it, that's not a security. We're not interested in prosecuting you people. We're not, right? Nothing. The judge, and when you see the transcript, it is telling. I brought this up to the judge on the record when we were in the hearing recently. I counted out how many times secondary market sales and the word clarity was uttered on the record in a 1 hour hearing. And it was 14 times that secondary market sales were raised, and 13 times the word clarity was used. And I said that to the judge. And the judge replied to me, I probably said most of it. And I said, you did. You did. And he then said, quote, am I frustrated with the SEC? Yes. Have I begged them to provide clarity to the market regarding secondary market sales? Yes. Can I do their job for them? No. Will I do their job for them? No. And see, that was the danger. And so what I did is I said, look, Judge, I'm here not asking you to do the SEC's job. I'm asking you to not provide clarity to the crypto market. I'm asking you to provide clarity of what your decision is. And if you don't mean secondary market sales, if you don't mean that your order applies to secondary market sales, you need to say that. You need to say it so that the SEC doesn't misapply your decision. So they don't then say, oh, look, it's implied or this or that. We need you to clear it. And so I literally stood up in court. I'm not ashamed of this. When he said, I'm not inclined to give an injunction. Don't worry about that, Mr. Deaton. I said, okay, that's great, Judge. I go, but please, I'm begging you. I'm pretty sure I used the words begging you. I'm begging you to provide clarity of your order that it doesn't apply to secondary market sales. And so that's really what happened. You know, some people, of course, have said it mean, you know, there's some people who've misquoted it and misquoted me and said that the judge said that no secondary market sale could ever be a security. He didn't say that. You know what I mean? He said his order doesn't apply. And his order, since it doesn't apply, it means that he's basically saying, listen, it's software code. It's a token. It could be used as a security by someone. It could not be. But my order doesn't apply to secondary market sales. So
you mentioned that we didn't get it in writing yet. It's in the transcript. When do you think we may see that in writing?
Well, a lot depends on how the judge approaches this. This hearing was a remedies hearing. The SEC was seeking that injunction. They were seeking disgorgement, meaning they wanted all the money that was ever sold, and they were seeking a fine. And the judge said he's not inclined to give an injunction. He said that since no fraud was ever alleged or proven or anything like that, that they're not bad actors, that he's more inclined to give like a $50,000 fine. And with disgorgement, it all comes down. He was basically said, if LBRY is going to dissolve and file bankruptcy or whatever it's going to do, you know, what am I going to disgorge them? They can't get blood out of a rock. You know what I mean?
Right.
And LBRY has stated that they're dissolving. They laid off their people, that their employees hadn't gotten paid since December, and that, quote, the SEC did what they threatened and they bankrupt us. And, you know, just recently, and this might be a good thing to talk about, Tony, just recently, you know, I know that there was some LBRY made a comment, and I know John Reed Stark, who, you know, is a former career SEC person, brought up, why would you say such negative things about the SEC? And then he said the SEC's never lost a crypto case. So I want to address that because it's a very important point. So if we could pull up Jeremy's LBRY, Jeremy Kauffman, this was his tweet a while back. And I want to focus on what he said. He says that they begged the SEC for 3 years to talk and explain to LBRY how to be compliant and how to do things, right? And that they refused. But then you see that last paragraph. It says, in private conversations, they, meaning the SEC, threatened to attempt to bankrupt our company through subpoena and discovery demands. Now, that's extraordinary. You have an American entrepreneur, CEO, saying that before the lawsuit, when they're in the investigative process, the SEC lawyers are basically threatening to bankrupt the company through subpoenas and through discovery, because remember, the taxpayer pays for this.
Yep.
Right? LBRY has limited resources. They're filing bankruptcy. They're dissolving. The U.S. government doesn't. Now, a lot of people are going to say, well, that's just Jeremy Kauffman. And Jeremy Kauffman's a character and this and that. You can't believe that. So let's see if it's true, right? There was a document filed not by Jeremy Kauffman, but by his lawyer. And this is the document. It was a pleading where they were objecting. But I want to go to the page that I've highlighted for your audience. And right there it is. This is the lawyer, not Jeremy Kauffman, saying, quote, let me read it. It says, time after time, the SEC returned to continue its pursuit of LBRY, and in an egregious abuse of power that revealed the SEC's malice toward LBRY, SEC staff threatened to continue issuing subpoenas to LBRY for voluminous materials in order to bankrupt the company if LBRY did not capitulate.
Hmm.
That's a lawyer, not Jeremy Kauffman, putting in a pleading as an officer of the court that he witnessed these threats of this agency saying, we're going to bankrupt you if you don't capitulate. So when people from the SEC get up there and say, the SEC's never lost the case, this is the kind of abuse that's going on. When Jeremy Kauffman said it in the tweet, I knew it was true because I've been around career prosecutors, and that's what the SEC enforcement lawyers are. They're prosecutors. They may not be criminal, but they're civil prosecutors prosecuting a violation or prosecuting fraud. And so let's talk about real things here. We've got 3 cases that we could talk about. LBRY, just to show people what I call the SEC bankrupt model. How do you make a company capitulate? Well, Jeremy Kauffman has said in LBRY they were investigated for over 3 years, and they spent between $1 and $2 million in the investigation. Dragon Chain was sued. Dragon Chain CEO said they spent over $2 million in a 3.5-year investigation. And on the eve of the statute of limitations, after being told the case was going to go away, they got sued, and now they have to hire a lawyer. Ripple has come out, Brad Garlinghouse, and said it's going to cost $100 million. So here's what people need to understand. When you are being investigated, they get to give you investigative subpoenas. They get to depose you. Brad Garlinghouse was deposed before the SEC ever filed a lawsuit. The Dragon Chain CEO was deposed before a lawsuit was filed. Jeremy Kauffman for LBRY was deposed before the lawsuit. So you have to hire these high experienced attorneys. These securities attorneys, Tony, they're billing. The Ripple lawyers are over 1,000, right? 1,000 an hour, $1,500 an hour. You're going to get $750 an hour. There's no securities lawyer that I know that's under 500, right? Wow. And that's like some boot out of law school doesn't know how to spell yet. Right. So if you've got a guy, a deposition they get 7 hours to do a deposition in federal court. They get 10 depositions each side. All right. 7 hours. If you got 2 lawyers representing you, like most of them do, you're at a minimum, you're paying $1,500 an hour. Each deposition is like 15 grand to 20 grand. And that doesn't count the prep time. That's just the deposition time. Right. Then you got the court reporter fees, the transcript fees. LBRY said they gave 1 million documents. Do you know what that means? That means a guy like me has got to make sure that there's not privileged material going out to the SEC. Got to make sure that this email between, it's not a lawyer and the attorney-client privilege doesn't apply. That means you're paying an attorney to look at every document being turned over. It is exhaustive. And so in the investigative stage, you're paying $2 million, and then you get sued, and then you got to pay another couple $1 million. And if you're an entrepreneur and you raised $3 million, right, they're going to take $2 million minimum from you in legal fees. And so people tap out. People are like, I just give up. I can't afford it, right? You're going to bankrupt me. And so that's our SEC. Our SEC has been proven to threaten people, to threaten entrepreneurs, to use the process as an abuse, to force them to comply. So let's just put it in perspective.
Yeah, I mean, it's almost like mob-like. And I remember Greg Kidd talk about this, like Tony Soprano. It's unbelievable that this is a government agency. They're supposed to have some integrity. They're using tax dollars and so forth. And I think what really solidified that for me was when Brian Armstrong, CEO of Coinbase, a publicly traded company, would go out and tweet that the SEC is acting shady. And this was around the time when Coinbase was, they were threatening Coinbase over the lend. But the fact that, once again, a company of that caliber and a person of that caliber will come out and say that, it just shows the SEC, they would almost use any tactics, it seems like, to shake these companies down.
Sure, that they have an agenda. And so just think about and everyone needs to understand these are non-fraud cases, right? Ripple is a non-fraud case. Dragon Chain, non-fraud case. LBRY, non-fraud case. And while these companies and entrepreneurs are spending millions of dollars in legal fees, we have the greatest fraudster since Madoff having private meetings with Gary Gensler. And why? Listen, let's say that Gary Gensler didn't do anything wrong. Why is he taking the meetings with the guy who has the Bahamian exchange, right? The guy who clearly FTT token, if there was a security, is the FTT token. Right. And yet you're meeting with this guy, and multiple times you're working out. They say Warren Davidson said there was some short form that they were trying to agree upon. You're going to give this guy a regulatory advantage while the #1 publicly traded exchange in the United States, Coinbase, you won't take a meeting with. I mean, that's where we're at. And so, there's these people out there. You can hate Ripple. You could think LBRY violated the law. You can think all those things, but you can't support this. The way that the SEC's acting, you can't support it. If you actually believe in the SEC, you should be just as offended as me, right? Or as you. You should say, this isn't the way we should do business. And so, but that is the way they're doing business. It's the SEC bankruptcy model. And that's how they get compliance, because who's going to say, I mean, think about all the people who are trying to innovate today. I know for a fact, because I talked to some of them, the first thing people say is, well, we're not going to offer anything to the US. We're not going to offer, this token or anything to US investors because we can't allocate 50% of our fundraising to lawyer fees. Right? It's already expensive enough to get licenses in different jurisdictions and to get legal fees and all of that, let alone say, okay, I'm going to have to spend, $2 million fighting the SEC. And so that's unfortunately what's happening. But everyone needs to understand that we have to fight this secondary market issue. Right. And I know one of your questions was about, I think you said about Ripple, right?
How does this impact the Ripple case? If the judge, in the LBRY case were to put it into writing, and once again, kind of setting the precedents here, could Ripple's lawyers in that situation use that as well? The secondary sales not affected?
Sure. If something came down in writing from the judge in his order that really made it a huge distinction that was helpful, what they would simply do is they would write a letter to the judge that says, please be aware this decision just came down. And it's a short, it would be like a short paragraph where they're saying, we just want you to be aware of this because it's relevant. Everyone needs to remember, if you go to the SEC's final brief, they cited the LBRY decision over 20 times. Right now, it's not binding. It's just one judge in New Hampshire and a judge in New York. They have different circuits. The judge in New Hampshire is in the First Circuit Court of Appeals. Judge Torres in the Ripple case is in the Second Circuit Court of Appeals, and there's different law and interpretations. But if it's helpful, then you just say, hey, judge, secondary market sales, that LBRY decision that they cite 25 times in their brief, it doesn't apply to secondary market sales, and we want you to know that, right? And so that's all it would be. So yes, they could do that. Whether or not they will is based on how he writes it. You
Sure.
know, does he write it and it's the way I would write it, and then it's amazing, right? Or does he get reserved? Does he say it exactly the way he said on the record, which is helpful? Or when he writes it, does he reserve it a little more? You know what I mean?
Mm.
And so I'm confident that we're going to get my ruling does not apply to the secondary market sales. That I'm confident because he promised. He literally at the end of the hearing, Tony, he told the SEC and LBRY what they were doing. Then he looked over at me and he goes, "And Amicus, blah blah blah. I'm going to make that crystal clear.
Mm.
Don't worry."
Yeah.
Basically, is what he was saying.
And John, what I think with the SEC and their actions, what also rubs people the wrong way is the Ethereum situation. And once again, nothing wrong with Ethereum. I hold Ethereum, my mom Ethereum, and so forth. But the way the SEC went about it, with Bill Hinman and Ethereum had an ICO, they never got penalized, they never got fined, they never got sued. But we kind of have an idea what took place there. So it's just like you see these double standards, right? The hypocrisy in these things. It just pisses me off. Like,
well, and it does, and I try to tell, and you said it yourself. I try to tell people, like, Ethereum it's just software code too.
Yeah.
And you can hate Ripple and own XRP. You could hate Vitalik or Joe Lubin and own ETH. Yeah. I'm just saying is that selective enforcement is really what it comes down to, right? Why did this group of entrepreneurs get a pass and this group of entrepreneurs did not? Mm-hmm. And that's why the conflicts are so important, because if you don't have a plausible explanation as to why, right? We go back to the Grunfest letter where he's like, listen, ETH and XRP should be treated the same. If XRP is a security, ETH's got to be a security. If ETH gets a free pass, XRP should get a free pass, at least in the secondary markets and whatnot in today's. And so when you don't have a really, really great explanation and you have these conflicts, it makes people be like, well, wait, is it because you were a member, your firm was a member of the Enterprise Ethereum Alliance? Is that why you did? Wait a minute. Now you're working at A16Z today, and they helped you with that speech. Mm-hmm. Was there a promise? Hey, I mean, I'm not saying, right? I know that Hinman violated the criminal conflict law. I'll say that, but I can't say that there was any quid pro quo, say this and you get a job or whatever. I'm not saying that. I'm just saying that's why conflicts are so important, because it takes away that, right? If we know that everything was done right, if we know that the speech was given a clearance by the ethics office, which we know it wasn't, but had it been, then you'd be like, okay, there's no foul play here. And so that's what's important. But selective enforcement is wild. And I know that, the ETH maxis will say, oh, ETH's much more decentralized. And the XRP maxis will say, now that the merge is, there's no way it's more decentralized. And I avoid that. And I still stand by this. I know I disappoint some of my XRP maxis, right, who are appreciative of me. And I love everybody, man, unless you're a mean, vicious asshole. But they'll be like, when I say, look, if the SEC has sued ETH and Vitalik and Joe Lubin, regardless of what I think about their behavior or their comments or, the regulatory thing, Hinman, any of that, I would have done exactly what I did in this case. I would have filed suit against the SEC. I would have said, if you're going to hold their ICO, hold them accountable, right? That's an unregistered securities offering, fine. But don't Don't say what I got, what Tony has, what Tony's mom has, what my daughter has. Don't say that that's an unregistered security. Because, dude, if you want to get theoretical, we can get into like the government. That's like violates the takings clause of the U.S. Constitution. You taking my property basically because you're devaluing it to zero potentially. And so that's where the fight is. And I really would love for there to be more unity about that. Like what I was doing in the LBRY case for secondary market sales. Like I know people who, because they DM me, who think XRP is a shitcoin.
Yeah.
Right. But they're like, hey, man, good job. Appreciate that. Right. They might not say it publicly because you can't compliment me, right? Because Hinman's at A16Z and I'm not getting invited to any of these industry kind of speaking engagements. And that's fine. I don't care because my heart is with the holder. But the point being is that we can all agree that when someone sells something subsequently, that doesn't mean it's a security, right? We can all agree that the token isn't a security, just like the oranges weren't securities.
And the other thing, John, I just confirmed, LBC was an ERC20 token. It was built on Ethereum. So there's a lot of tokens out there that are running on Ethereum, which the SEC in the past, of course, has said is not a security. So I don't know how all that works together, but it does come back to, like you were saying, it's the packaging, right? But the token itself, not a security, but that's another dynamic.
No, it's a great point, and it's something that Dragon Chain I brought up to you. Dragon Chain is an ERC20 token that's governed by the Ethereum blockchain. Yeah. So if Bill Hinman gets up and says, whatever it means, Ethereum is, quote, sufficiently decentralized, and therefore there's no need for disclosures, there's no need for registration, it's not a security. How is an ERC20 token governed by the very same sufficiently decentralized blockchain not a security? I mean, or a security, and so that's what needs to be flushed out. And a lot of people think that I'm anti-regulation. I'm anti-overreach. I'm anti-government bullying, right? I'm anti-threatening people, entrepreneurs. But I'm 100% for regulatory clarity. I want Congress to come down and say, here's a security token. This is the definition of a security token. This is the definition of an exchange token. This is the definition of a utility token. This is when a token transfers from being a commodity to a security. Or when something's a security, when it morphs into a non-security because of these 5 factors. I'm picking 5. It could be 3 factors, right?
Sure.
Or we have Hester Peirce's, as you've interviewed several times, her safe harbor that simply says, you know what? Here are 3 to 5 markers. If you meet these markers in the next 3 years, then you get to be, right? We could say, we're going to open up, we're going to allow ICOs to a certain extent, and you've got 3 years to be a sufficiently decentralized, let's use that term. If you meet these markers, you then become a commodity. And the spot market is governed by the CFTC. If you don't meet that within those 3 years, then you're a security and you're registered, right? Or you're out of business. And so like something that holds people accountable to comply with the laws, but fosters innovation and fosters some kind of growth. And it's unfortunate because you and I are sitting here like we're fighting in a New Hampshire federal court in Concord, New Hampshire, at a remedies hearing, because that one little thing could be applied across the country, and we're fighting tooth and nail at these little hearings because we're not getting clarity. And in the meantime, you have the UK saying they want to be the crypto hub. Hong Kong wants to be the crypto hub. The UAE wants to be the crypto hub of the world. Singapore, Switzerland, they're all saying, hey, go ahead, America, keep fooling around. And while we move past and we move on into the future and leave the United States behind. So, hopefully we get something, but
Yeah.
it's not going to be this year, brother. Not from Congress. I mean, if you think that this Congress is going to come up with something that's going to pass the Senate and the House and Biden's going to sign it into law, I mean, I hope they prove me wrong. Like, I'd love to eat my words. I would be so happy to say I was wrong, but I don't see it.
Yeah, that's what I'm hoping too. I'm not too optimistic, but I'm hoping that they can rally together, because we do see some bipartisan support, but we need more. It's just a handful right now, but we'll see how things play out. There was a lot of questions that people wanted to get your thoughts on Ripple and the case there. When we may see summary judgment, and if judgment is passed, can the SEC appeal?
Yeah, I think one of your questions that I saw was about oral argument. If the judge was going to hold an oral argument, chances are she would have held it by now. You know what I mean? Also, she doesn't hold an oral argument unless the parties ask for it. And I can't remember whether Ripple and the SEC, when they filed their summary judgment, if they then, asked for it, because her local rules, when you file a motion, you have to send her an email that says you want an oral argument. There's a good chance that Ripple didn't ask for an oral argument because they just want to rest on their papers, right? And the SEC may not have asked for it. And so I would say at this point, although I'm surprised she didn't have one because of a case of this magnitude, to flush out some arguments, maybe cross-examine the attorneys on why. I would have loved to seen her reaction to the SEC's theory. It keeps changing, you know what I mean? But at this point, I don't think it's going to happen. Oral argument. Yes, each side can appeal. So, I know I disappointed a lot of people when I said that my opinion is that there will not be a settlement before a summary judgment ruling. But often what happens is when you get a summary judgment ruling, then there can be a settlement. So let's say that Ripple, let's say they just flat out win, right? The SEC could say, well, if you agree to pay a fine for some early sales and the judge gave you what you wanted, XRP is not a security moving forward, we won't appeal it. So Ripple could say, well, we want the finality. Here's a $25 million fine, and there's a settlement. If the SEC, if there's a split win where the judge says, Ripple violated this, but XRP is not a security, there could be a settlement. The real danger, Tony, and it's something that would probably really, really test. XRP holders have been tested. We all can agree. Their patience has been tested like no other token holder. But there is a possibility of one more gigantic test. And that is if the judge says motion for summary judgment of the SEC denied, motion for Ripple for summary judgment denied, a jury must decide certain factors, right? Was there non-investment use for XRP? Is there a common enterprise that exists? like she could, and I can't tell you what those chances are for that because a lot of the evidence is still sealed, right? And so I don't know what both sides agreed upon. Usually in a securities case, both sides will agree with enough facts that you don't need a jury to decide because they're in agreement of the facts, of enough facts that the judge then says, okay, there's no need for a jury. These are the facts, and I can apply the law and render a decision. But if there's enough disputed facts between the parties, then there would be. Also, Ripple in their papers stated that whether or not Ripple received fair notice is a jury question. Now, most people don't want the judge to get to fair notice because if she gets to fair notice, she found XRP to be a security at some point, not the token, but that Ripple used it.
Right.
And now the fair notice is, well, we should be excused from it. And so, so there is that danger. And I've went on record to say, not enough people, a lot of people are underestimating the chance. I don't know what the chances are. I don't remember what Jeremy Hogan, I know he did his percentages and I don't know where he put a jury trial at, but it's not 1%. It's higher than that. You know what I mean? So if there's a jury trial on something, then we could get no clarity because a jury trial has to happen.
Now, John, there is a class action lawsuit in California, and this is some breaking news here from you. Tell us about what is going on there and how you're involved.
Well, the class action, a handful of people, one guy filed a lawsuit in May of 2018 against Ripple, and he claimed that XRP was a security. And that guy, his case was dismissed, but he had only held XRP for like a couple days. He lost like $180 or $160 or something. I don't know. But there were several other lawsuits that filed, people claiming the same thing. And a class action is just like what I filed. I filed against the SEC was I named, 6 individual XRP holders, but then I said, and all others similarly situated. And so we have 5 or 6 individual XRP holders in California court who are saying that XRP is a security, that when they bought XRP, it entered into a common enterprise with Ripple, and that they were relying on the efforts of Ripple and they lost money. Well, the problem is, and Ripple is going to file their objection today, but that attorney has moved the court, filed a motion to have the class certified. And there'd be a certified class action instead of what's called a putative class. It's a certified class. The problem is the lawyer says that this individual XRP holder is going to represent, quote, any XRP holder who purchased XRP in May of 2017 until today, who either still owns XRP or lost money. So that individual saying he represents Tony, Tony's mom, and the 75,000 people who have said the opposite. And the problem is they didn't limit. I wouldn't get involved if they were just saying any XRP holder who purchased from Ripple or its executives, right? Then I got nothing to say. I wouldn't have been involved in the SEC if they'd have done that. I wouldn't have been involved in LBRY if they'd have done that. But this plaintiff's attorney is saying all sales of XRP are securities. He's doing the same shit. Yes. Secondary sales, the token itself. So he's saying the same exact shit that the SEC was saying. And so I am going to object on behalf of XRP holders that this guy's not a representative of Tony's mom. He's not a representative of my daughter. He's not a representative of the 6 XRP holders who were in the Ripple case, right? And that we have 75,000 people who say the opposite. How many does he have? Because I've only counted 5. And so I just want to let the judge to know that that is too overbroad. In other words, it's the same thing the SEC is doing, except it's a private person doing it, and that I want her to know about it. And this judge could say no to me, could listen to me, who knows? But we have to fight the token itself being called a security and protect secondary market sales, whether it's the government or an individual.
John, I got 2 things I want to say about that. First, I have a gut feeling some of these people are plants. I don't know if they're from the SEC or other competitors. Second, if you bought XRP in 2017 and May 2017, and you didn't make money in the run up with Bitcoin into December and January, then you're a clown.
Well, listen, I can appreciate your point. My point is this, and I've read these plaintiffs. If you bought XRP and you held it for 2 weeks and sold it, then how are you relying on the efforts of Ripple? Let's just talk common sense. Like, by definition, you're not relying on the efforts of Ripple. You didn't give them enough time, right?
Yeah.
Like if you were still holding it for 5 years, right, saying I want Ripple to fulfill a promise, and you bought it from Ripple, then I wouldn't say anything. I might disagree with you and all that, but I wouldn't get involved. But if you're going to, say, I bought XRP on Monday and on Friday I sold it and I lost $60 and I'm pissed off at Ripple because they didn't, and I relied on them, then, that doesn't pass the laugh test.
Okay.
And, all I can tell you is, it is very suspicious of the timing of this lawsuit, but the bottom line is I'm representing XRP holders, not Ripple. So I'm going to say the same thing. Tony, I'm very consistent. I'm going to say the same thing. If you got a problem with Ripple, fine. Keep it to Ripple. Leave us out of it.
Yeah.
Right. Quit claiming that what I own or what you own in and of itself is an unregistered security. The facts don't support it. Common sense don't support it. And a century of case law doesn't support it. So stop doing it. But there's lots of agendas at play here. And on top of that, the final thing I say about this private class action is, if the SEC wins, that case is useless, because you can't, if the SEC wins and collects $1 billion from Ripple, they're going to create a trust, right? And try to reimburse XRP holders. Well, that civil lawsuit, you don't get to double dip. You don't get to say, oh, we get $1 billion too, and we're going to give. So it kind of makes no sense. Like that they wouldn't wait until the result of this case. And so all I want to do is say to the judge, we're a few months away from a decision. This case was filed in 2018. It can last. It can wait a few more months. Let's see what the judge says. If the judge agrees with the SEC, then, whatever, and you want to certify the class, go ahead. If the judge comes back and says direct sales only, secondary market sales are not in play, like the LBRY judge, then that will affect this civil lawsuit as well. You would think, right? And so, but that's the problem, is that it's just overbroad, way overbroad. And so, I'm like, just imagine this, Tony. I've spent over 20 years and never an amicus. Now it seems like I'm amicus everywhere I go. You know what I mean?
Yeah, I appreciate it, John. You know, like you said, you're fighting on behalf of the holders, and there's a lot of holders. Once again, if you hate Ripple, that's fine. But if you're holding other tokens, it's just a matter of time for the SEC to work their way down the list, whether it be Cardano, Algorand, whatever it is. They'll get to it.
Imagine if the SEC and Gary Gensler got a complete victory. Imagine if the Judge Torres, I don't think she will, but imagine theoretically if she said XRP is a security and it's a security no matter who sells it.
Yeah.
Does anybody think realistically that the SEC is not going to call XLM up?
Oh my gosh.
That they're not going to call Cardano up? That they're not going to call, I mean, maybe they don't algo because he was friends with the guy. I don't know, right? But I'm just saying is that every one of the top tokens were being played. ETH would be in play. There is no doubt. Gary Gensler is already implied, maybe even expressed, I can't remember, that the merge and move to proof of stake, quote, implicated securities laws. So they'll use it. They'll use it against ETH too. 100%.
Yeah, and even real quick, I was talking to somebody else about this. Rostin Benham, I think he's the acting chair of the CFTC. He also backtracked on ETH being a commodity. So things are,
That's scary.
It's
That's
setting
scary.
up. Yeah.
Cynthia Loomis, Senator Loomis, backtracked on it too.
Yeah.
Right. They get back there and they said, no, Gary Gensler's back there talking about the merge and all that. There is an agenda. There is a war against crypto. It is absolutely a war. It's been waged. It's going to continue to wage by the SEC. And that's why these fights in the court battles are so important.
For sure. Final item here before I let you go. Folks wanted to know about, Hinman documents and emails. Will those see the light of day? And if, the Ripple is told they can't release or show anything, can they highlight what may have been in those emails? I don't know if that's a legit.
Well, there's what's called a protective order. So when each side marks something confidential, the other side can't disclose it. So, for example, Ripple would have marked financial statements of Brad Garlinghouse, right? That's confidential. And so therefore the SEC can't say, well, Brad Garlinghouse is worth X amount of dollars, right? SEC has marked the Hinman stuff as confidential. So Ripple can't disclose it even if they want to. They can't say, well, I'm not going to give you the document, but let me quote it. They can't do that. They can describe it. It'll shock you. It's abusive behavior, whatever, but they can't quote it. It all comes down to the Judge Torres. If Judge Torres relies on the Hinman emails in any way, the law is her reliance turns it into a judicial document. And what that means is that there is a very strong presumption that it will be made public. It can have redactions. It can redact the name. It can redact the address, an email, but the substance of it must be made public unless there are extraordinary reasons not to. And so if she relies on them, they're going to be made public. The other problem is what we were talking about, the ERC20 tokens. Do you think that lawyers for Dragon Chain, if ERC20, Dragon is an ERC20 token, do you think that they don't want the emails?
Oh, yeah.
Of course they do, because they have a fair notice defense. It's really, when you think about it, Tony, what's more relevant? An ERC20 token should know all the Hinman stuff and the ETH is sufficiently decentralized, or XRP? There's an argument that the ERC20 token company like Dragon Chain has a right to those emails even more than Ripple did.
Yeah.
Right? Because the same Ethereum blockchain. So it's going to continue to get litigated. And so I believe we're going to see those emails at some point. Brad Garlinghouse tweeted, when they're eventually made public, right? Now, the question is that in the next couple months, or is that 2 years from now? But eventually we're going to find out. It's also why I said to people, I don't think the emails now are going to force the SEC to settle, because they already gave it to Ripple. Ripple's already talked about how it's going to shock people. There's FOIA requests for it. There's more litigation with Dragon Chain and LBRY and all these other companies. Other tokens are going to seek it. I think that they realize they can't put that genie back in the bottle.
Yeah.
And so, sure, they could come to a deal, and then in the Ripple case, it never gets disclosed. But I think we're going to see them, how bad they are, we'll see. I think it's safe to say that there's people who commented that if you give this speech, it's going to cause confusion. It's going to cause market confusion, you know what I mean, and things of that nature. So,
John, thank you for keeping up the good fight, and on behalf of all crypto holders. I know I thank you all the time, but seriously, I know it's time out of your day. You got a business to run. Definitely appreciate you, man.
All right. No, I appreciate you too. Thanks for having me, brother.